Good morning, and welcome to Coffee Talk, our health seminars series. My name is Kathryn Frelick, and with me is Greg Bush, and we are delighted to be here this morning with you to talk about up-to-the-minute COVID-19 developments. They really are up to the minute. Things are changing so quickly that it's difficult to keep on top of all of the changes that are happening. So we will try to do our best to help you with that today. And we will divide our presentation into two parts. So I will speak first, followed by Greg Bush, who will speak about labor and employment developments. As a housekeeping matter, if you could please ensure that you mute your microphones, as the ambient sound can interfere with the presentation. This will be a full hour. There's a lot of material to go through, but I do invite you to contact either of us through our contact details, and we would be delighted to answer any of your questions following the presentation. So in terms of my portion of the discussion this morning, we're going to talk about public health and emergency management powers and orders and authorities, some discussion around decision-making and legal risk in a public health emergency, and strategies for managing risk. As you know, we are in an unprecedented situation right now, dealing with the speed and scale of transmission of this novel coronavirus, which led to a decision by World Health Organization to identify COVID-19 as a pandemic earlier this month on March the 11th. A pandemic is the worldwide spread of a new disease, as defined by the World Health Organization. And some of the key factors that we are seeing here that increase the risk and the concern is the fact that people lack pre-existing immunity to the new virus. A large portion of the population is infected or can be infected. And even if there's only a small proportion of individuals who go on to develop severe disease, the total number of severe cases can be quite large. When we're dealing with large-scale public health events, there's a need for coordination at all levels of government. We have seen the SARS situation and the H1N1 influenza epidemic and responses to those really showed some of the gaps that were evident in our systems and our ability to manage large-scale public health events. This prompted some significant legislative and policy changes to address federal and provincial responses, both from an emergency management and a public health perspective. In 2018, the Pan-Canadian Public Health Network developed a federal, provincial, territorial public health response plan for biological events, which includes events such as pandemics, which provides a governance framework and guidance for public health emergencies. And it goes into the manner in which, particularly at the federal and provincial levels, the cooperation and that will take place on those levels. All levels of government do have legislation to address emergency management planning and public health. There are requirements at all levels for organizations and government agencies to have emergency management plans in place. That includes municipalities. And the purpose of having those plans is to ensure that there's effective engagement and communication among public health, healthcare delivery, and emergency management authorities. Some health service providers will also know that will also have requirements to have their own emergency management plans. Under Regulation 965 of the Public Hospitals Act, for example, there is a requirement for a hospital board to ensure that there are plans in place to address situations of where resources are overwhelmed. So what are we talking about when we're dealing with public health versus emergency management? What are the responsibilities for each? When we're talking about public health activities, we're talking about activities to manage the response to a public health event. And that can be done in a number of different ways through disease monitoring, reporting and surveillance, public education, laboratory testing, evidence-informed recommendations. And as you know, there have been a number of different guidelines and recommendations that have been circulated by public health, providing direction to health service providers on how to manage and address COVID-19. Emergency management coordination it really deals with the coordination of responses to public health events. And there are a number of areas in which this is done through mutual assistance and supply management. And by mutual assistance, what we mean is ensuring that organizations are available to mobilize and assist each other when there is a need, and that may include assistance through provision of human resources, as well as other types of supplies and resources to help manage the situation. It also includes supply management, logistical guidance and support, the sharing of information amongst all stakeholders, and sharing of resources both across the health sector and with other sectors as well. In terms of the federal legislation, there are three main pieces of legislation that make up the legislative framework. First is the Public Health Agency of Canada Act. This is the legislation that establishes the Public Health Agency of Canada and the role of the Chief Public Health Officer for Canada. There is the Quarantine Act, which provides authority to implement measures to protect public health, which includes prevention and spread of communicable disease. There have been several orders in council that have been issued relating to travel restrictions and screening restrictions. These are increasingly becoming more stringent as the window to respond to this crisis closes. Finally, there is the Emergencies Act. Now, no federal emergency has been declared to date, and there are certainly calls on the federal government to take these steps. It's a very extraordinary measure, and the government of Canada may only declare a national emergency in an urgent and critical situation of a temporary nature that seriously endangers the lives, health, or safety of Canadians and is in such proportions or nature as to exceed the capacity or authority of a province to deal with it. So it may only be proclaimed if other laws are inadequate to respond effectively to the crisis. And the federal government is certainly reluctant to call a federal emergency where the provinces are actively engaged in managing the pandemic at a provincial level. But as I said, there are increasing calls upon the federal government to take those actions. In Ontario, we have two pieces of legislation that deal with public health and emergency management. The Health Protection and Promotion Act deals with the roles and authority of public health units, your local medical officers of health, and the Chief Medical Officer of Health, who is responsible for oversight of the public health system in the province. There are, in addition to the delivery of many different public health programs and services, they have a mandate over the control of infectious diseases and diseases of public health significance within their particular geographic area. At the local level, public health is responsible for investigating and responding to all reports of suspected and confirmed cases of COVID-19. As you know, the legislation was amended prior at the beginning of this situation, and coronavirus was designated by regulation as a reportable disease of public health significance and a communicable disease under the HPPA. As you know, the the medical officer of health has a broad authority under the legislation to issue orders and directives. And some of these authorities include the closure of premises, ordering cleaning and disinfecting of premises, that persons go into quarantine, that individuals be tested or examined by a physician, etc. They also have the authority to issue directions where a person refuses or is not complying with an order, or where certain circumstances exist. And there are, it's an offense under the legislation to fail to obey an order. That is punishable upon conviction of significant fines for individuals of not more than $5,000 per day for every day that the offense occurs. For corporations, they may be subject to a $25,000 maximum penalty for every day that the offense occurs. And there is also potential liability for officers and directors, and a need to ensure that they are acting reasonably in circumstances. The provincial chief medical officer of health has additional powers and authorities to investigate and take steps to prevent, eliminate, or decrease any situation that constitutes a high risk in the province. That includes ordering an occupier of premises to provide the premises to the minister to be used for public health purposes, ordering the emergency procurement of medications and supplies, directing any health information custodian to provide information, and issuing directives to any healthcare provider or entity relating to precautions and procedures to be followed. The other piece of legislation that deals with the provincial powers is the Emergency Management and Civil Protection Act. And this legislation initially was developed to address terrorist threats, such as right after the 9/11 terrorist situation. It was amended following SARS, and many different amendments were made. And it defines an emergency as a situation or an impending situation that constitutes a danger of major proportions that could result in serious harm to persons and that is caused by a disease or other risk. So it's much broader than that, but I've only pulled out the sections that are really relevant to this situation. The declaration of emergency can be declared by the Lieutenant Governor and Council. And as you know, Ontario declared an emergency on March 17th of this year. In order to declare an emergency, there is a need for immediate action to prevent, reduce, or mitigate the danger of major proportions. And you may have heard the Premier speak in terms of a danger of major proportions that could result in serious harm to persons, and where resources that are required are either not available or it can't be determined that they are available or they are insufficient to effectively address the situation. The types of emergency orders that the Lieutenant Governor and Council can order include the establishment of shelters or hospitals. Importantly, using any necessary goods, services, and resources within any part of the province, procuring goods and services and resources, and distributing and establishing centers for their distribution. And as we'll speak a little bit later, those are really critical roles and functions at this time, given the shortages in the province of critical resources and equipment. They can order closing of any public or private building, including any business, and they can authorize but not require a person to provide services of a type that the person is reasonably qualified to provide. So it doesn't necessarily need to be something that they usually provide, but are able to provide in a reasonable manner in the state of emergency. There are a few limitations on emergency orders. They must be exercised in a minimally intrusive manner. They must only apply to areas of the province where necessary. In this situation, the state of emergency has been declared to be province-wide. And they must only be effected for as long as necessary. They are valid for 14 days, but they may be extended through a number of periods of no more than 14 days at a time. To date, 9 orders have been issued under the legislation. And I'm going to focus on 2 of the orders which relate to implementation measures that allow hospitals to respond to the COVID-19 outbreak as well as work deployment measures in long-term care homes. We expect that there will be future orders that will follow that impact on health service providers across the continuum of care in responding to COVID-19. The March 21st emergency order applies to certain health service providers, and that includes public and private hospitals, that should be, and psychiatric facilities. And the March 24th emergency order applies to long-term care homes. Health service providers are authorized with respect to work deployment and staffing to take any reasonably necessary measure to respond to, prevent, and alleviate the outbreak of COVID-19. Greg will be spending some time during his presentation talking about some of the labor and employment implications of these orders. But I did want to highlight a few interesting and noteworthy provisions that that have other types of implications as well, and which do raise a number of risk issues that health service providers will need to be alive to. One is using volunteers to perform work, and we'll talk about some of those risks in a little bit. The ability to conduct skills and experience inventories of staff to identify alternative roles and priority areas, to require information from staff or contractors. So this one is not restricted to staff alone, about their availability to provide services, and to require information from staff or contractors about their likely exposure to COVID-19 or other health conditions that may impact on their ability to provide care. They can also, under this authority, cancel or postpone services that are not related to responding to, preventing, or alleviating COVID-19. So now we'll talk about some of the decision-making and legal risk in a public health emergency. Obviously, COVID-19 presents challenges for all health service providers. The response to the pandemic will require a sustained response over a long period of time. The response requires broader system solutions, communication and support at all levels, from the federal, provincial, regional, and local levels. Some of this is in your within your control. Other aspects which are not. So when we're looking at what your legal obligations are as a health service provider, you owe a direct duty of care to your patients, residents, or clients. I will use patients throughout, but that includes all three. So that includes the obligation to provide qualified staff, proper instruction and supervision, appropriate facilities and equipment, and to establish appropriate systems, policies, and procedures. As an employer, health service providers are vicariously liable for the acts and omissions of their employed staff. And they also have obligations to their employees directly, including the obligation under the occupational health and safety legislation to take every precaution reasonable in the circumstances for the protection of employees. Anticipated impacts of the COVID-19 pandemic include And we're already seeing all of these things coming to fruition. Critical shortages of human resources, critical shortages of testing kits, of essential supplies and equipment, including ventilators, and personal protective equipment, gloves, masks, and respirators. There's a lack of capacity where health service providers are being overwhelmed, particularly where there are outbreaks in facilities that really very quickly overwhelm the local system. And health service providers must manage the risk and look at their processes to respond and adapt to these extraordinary events. We'll speak a bit about some of these three areas, one being the critical shortage of human resources. And health service providers are finding themselves using volunteers, using employees in alternative roles, and seeking assistance from retired health professionals and those in the community who are not usually providing care. The key issue that I note here is that as a health service provider, you must ensure that the individual is trained and educated to perform the particular task. And so having an assessment of the individual's skills, ensuring that they are able to provide the service in the circumstances. The Ministry of Health has launched a website where current or former members of a regulated health profession can indicate a willingness to assist. And the professional colleges are fast-tracking registration for various regulated health professionals to support COVID-19 responses. This may be through the creation of new categories, such as an emergency status or time-limited registration on a temporary basis. We're also seeing a greater use of virtual care and provisions for virtual care. And those are happening across the province at every level of care, which of course bring their own potential risks with them, particularly privacy risk. And I'm just referring to one of the colleges. The CPSO has a public health emergencies policy, which enables physicians to depart from an expectation to practice within their scope of practice, where there is an urgent medical need, where another physician is not available to provide the care, and where they are not putting patients at greater risk. From a professional staff perspective, hospitals may need to shift physician schedules or bring on additional physician resources, which may have implications on existing physician privileges and or which may require the expeditious granting of privileges. The scheduling of shifts may be justified if the dominant purpose is quality of care and emergencies arising from COVID-19. This should be done in an equitable manner in accordance with the hospital's bylaws. There's a great deal of media attention right now and concern expressed at all levels by health service providers and health service provider associations and organizations relating to the critical shortages of equipment and supplies. As you know, there are many different activities that are taking place right now. Donation drives for personal protective equipment, donation of materials, use of volunteers to make masks and other types of basic supplies. Consideration of use of expired supplies and equipment, or rationalizing that supplies. Many organizations did stockpile N95 masks following SARS, and there are a number of organizations that still have that equipment that has expired, and are asking whether or not, or looking at whether or not they can be used in a situation where that's really a last resort. Industry is repurposing and manufacturing different ventilator components, masks, hand sanitizer, and other products. And with this brings various risks around manufacturing standards, quality control, whether they are effective for use, how these are, your staff will be trained in using these supplies and licensing, etc. Issues around access to critical resources is another very difficult question. It's in the healthcare system, we have dealt with allocation of scarce resources for many years, but not in a situation like this, where there is a huge need for ventilator treatment where there are severe cases of COVID-19. So some of the questions to ask are, first and foremost, is the individual an appropriate candidate for ventilation? And what is the standard of care? Physicians are entitled to exercise their professional judgment as to the suitability of an intervention and whether or not they will propose ventilation as a treatment. So you're not required to provide a treatment that in the professional judgment of the physician is inappropriate. And use of ventilators, it's highly invasive. It's a very, there is a significant risk for particular individuals when using ventilators, particularly if they have other medical conditions or are frail. What are the individual's wishes? Has there been a discussion with individuals about what their wishes would be in the event that there is a need for these types of interventions? And that can take place in many different care settings, so that there is a plan in place to try to address this situation in a proactive way. Make sure that you work with your partner organizations so that you're looking at these resources from a systems perspective. They're all connected, and the long-term care home doesn't want to send an individual to a hospital where the hospital is going to turn around and send that individual back because it's not appropriate in the judgment of the health professionals to use ventilation in a particular circumstance. So working together with your partners is key. When we're looking at these situations from a legal liability perspective, there's not a lot of cases that have dealt with these issues. Generally, though, hospitals and physicians are judged by the standards reasonably expected by the community that they serve, which includes availability of resources, and certainly the situation of a public health emergency would be factored into the standard of care for individuals and health service providers. One court in Ontario has stated, for example, that a doctor cannot reasonably be expected to provide care which is unavailable or impracticable due to the scarcity of resources. And in a public health emergency, all health service providers will be expected to do their best within their resource constraints and act reasonably in the circumstances. So what is reasonable in the circumstances? There are a number of things that you can do, but most of all, it's making sure that you have carefully considered and documented and assessed, the various options and risks in order to satisfy yourself that that you've done what you can. That may include implementing or adapting policies and procedures, ensuring that you document all attempts to identify or source equipment, supplies, or resources. Our memories are not great, so ensuring that you have this documented will be very important for a later date as memories fade and there's a need to be able to determine what decisions were made and how. Rely on ethical frameworks for decision making. Many organizations have ethical frameworks for making difficult decisions. There may be access to an ethicist, and even if you don't have your own ethicist, there are other organizations that do have those types of resources. Rely on evidence-based standards and protocols. Make sure you undertake a risk analysis for critical decisions. And again, ensure that you've documented your decision-making process. There are not perfect solutions, but you want to be able to demonstrate that you looked at the situation with a critical eye and carefully considered the options in making a decision. Make sure that you work with your partners. And I can't stress this enough. We are all in it together, and everybody really has to do their part. But it does take a level of coordination with other organizations because no one can do it on their own. From a professional liability perspective, when a physician is relying on their professional judgment, it could be another health professional as well. Any decision relating to rationalizing resources ought to be made on proper consideration. So that means it can't be based on arbitrary or unfair factors. It should be done in consideration of professional policies and guidelines. And again, utilize ethical decision-making frameworks and resources to help support decision-making where that is available. So in wrapping up, there are a number of risk management strategies that you can take to address the situation, and these are just a small number of different measures you can take. including implementing your pandemic or emergency management plan. Consider developing a community action protocol or forum to coordinate COVID-19 responses and address the roles and responsibilities of community partners. And, by community partners, we're talking about the entire continuum of care and, how you will work together to communicate to individuals in the community and provide access to resources. Monitor evolving legal and regulatory requirements. These are changing every day. Identify your requirements for ensuring continuity of core essential services. Develop a plan for workforce shortages. Develop and coordinate internal and external communications for anticipated scenarios. In many cases, you will not have a lot of time to act. So having these developed in advance can be save some very important time. Ensure that when you're using new solutions, that you undergo an appropriate risk assessment. It's things are moving very quickly, and it's easy to forego those types of steps. But even if it's something is better than nothing. Ensure that you document any roles and responsibilities with partnerships and deal with issues of allocation of risk and liability. And develop a plan for responding to medical equipment supply shortages to ensure safety of patients, staff, and the community. This is a rapidly changing situation, and accurate and timely communication is essential in this time to ensure effective collaboration and cooperation, public awareness and trust. And again, please document your decision making. It's much more difficult to try to recreate it after the fact, and that will put you in good stead. So with that, I am going to pass it over to Greg.
Great, thanks, Kathryn. I'm going to now talk about a few labor and employment-related considerations that have come up as a result of COVID-19. Given our time constraints today, I'm just going to focus on a few in particular. So I'll go over the two recent orders from the provincial government that affect hospitals and long-term care homes. I'm going to touch on some of the new and existing leaves of absence that employees may be entitled to as a result of COVID-19. I'm going to discuss a few health and safety concerns in the workplace, work refusals, and I'm going to briefly touch on employment insurance benefits and the federal government's new support benefit for employees or individuals who have stopped earning income as a result of COVID-19. As Kathryn mentioned, the Ontario government announced a new temporary order on March 21st. That order makes wide-ranging changes to how health service providers are able to deal with their employees. The order grants hospitals the power to take, with respect to work deployment and staffing, any reasonably necessary measures to respond to, prevent, and alleviate the outbreak of COVID-19 for patients. The order itself does provide a list of a non-exhaustive list of specific measures that hospitals are permitted to take. Some of those are listed here, and those include redeploying staff within different locations in hospital facilities, redeploying staff to work in COVID-19 assessment centers, changing the assignment of work, including assigning non-bargaining unit employees or contractors to perform bargaining unit work, changing the scheduling of work or shift assignments, deferring or canceling vacations, absences, or other leaves, regardless of whether those vacations, absences, or leaves are established by statute, by regulation, agreement, and that includes collective agreements or otherwise. They're permitted to employ part-time or temporary staff or contractors, including for the purposes of performing bargaining unit work. As Kathryn mentioned, using volunteers to perform work, including bargaining unit work, and providing appropriate training or education as needed to staff and volunteers to achieve the purposes of a staff redeployment plan. On March 23rd, the provincial government enacted similar order to allow long-term care homes to carry out virtually the same measures now afforded to other health service providers. When used by hospitals or long-term care homes, these redeployment plans temporarily supersede the provisions of a collective agreement, and that includes any provisions surrounding layoff, seniority, service, and bumping provisions. For example, a hospital would usually be required to post a layoff notice, wait a period of time before being able to move a nurse or other unionized employee from an emergency department to a COVID-19 assessment center. However, these new measures would allow for the redeployment of staff to address the containment of COVID-19 without any restriction or delay. These orders are time limited for 14 days unless they are revoked or renewed in accordance with the Emergency Management and Civil Protection Act. Now, while these temporary measures will likely help ensure our healthcare system can properly respond to the pandemic, both hospitals and long-term care homes should expect that any workplace changes will be closely scrutinized by both unions and their members. To the extent possible, any changes implemented in accordance with these measures should only be made when necessary and when there's a demonstrated need to do so. The actual wording of the order leaves things pretty open to unions to challenge whether a particular measure is reasonably necessary to deal with a pandemic, though the order itself actually limits the ability to grieve during the period of the order. So any grievances can only happen after the order is revoked. And actually, just yesterday, the presidents of the Ontario Federation of Labour, the Ontario Council of Hospital Unions, QP and SEIU Healthcare wrote a joint letter to the provincial government urging it not to extend the order beyond the initial 14-day period, arguing that there had been no difficulty thus far in transferring or assigning staff as required. It's difficult to say right now whether the province has plans to extend the order or not, though absent any significant developments, it's possible the order will remain in effect until things begin to settle down. Next, going to go over a bit about leaves of absence that employees may be entitled to, both as a result of COVID-19 and some of the existing leaves. Back on March 16th, the government announced it would be implementing new job-protected leaves relating to COVID-19. And on March 19th, the government officially passed those amendments to the emergency leave provisions of the Employment Standards Act. Now, these amendments provide that employees are entitled to an unpaid leave of absence in certain circumstances, such as when they are under medical investigation, supervision, or treatment for COVID-19, when the employee is acting in accordance with an order under the Health Protection and Promotion Act, when the employee is in isolation or quarantine in accordance with public health information or direction, when the employer directs the employee not to work due to a concern that COVID-19 could be spread in the workplace by the employee, where the employee needs to provide care to a person for a reason related to COVID-19, such as a school or daycare closure, or where the employee is prevented from returning to Ontario because of travel restrictions. Now, apart from the circumstance where the employer can direct the employee not to attend at work due to concerns about spreading COVID-19, it's generally up to the employee whether or not they want to take one of these leaves that are available to them. In terms of supporting documentation, an employer cannot necessarily ask, or an employee cannot be required to provide a medical note if they need to take one of these leaves of absence. However, employers are generally able to ask employees to provide other evidence that is reasonable in the circumstances at a time that is reasonable in the circumstances. In terms of the government's guidance, they've said that reasonable evidence can be something like a note from a daycare or canceled flight itinerary. That said, it's safe to say that any employee who is asserting an entitlement to this leave will still have a good chance of getting it given the current state of emergency, the fact that people are being told to stay home, that schools and daycares are closed, and that parents need to look after their children. For those employees that are covered by a collective agreement, it's quite possible that the collective agreement does not directly deal with these situations and therefore might not provide a greater right or benefit in these specific circumstances. So unionized employers should be aware that employees may have access to this leave in addition to what they would usually have under the collective agreement. Employees who qualify for one of these leaves do not need to be paid, but they do remain entitled to employee benefits during the period of leave, and they can apply for EI or any other government supports if they're eligible. Now, what leaves are available to employees who self-isolate or are quarantined because they are ill? So if an employee is sick and otherwise doesn't qualify for one of the new COVID-19 related leaves, they do remain entitled to sick leave under the Employment Standards Act, which provides for up to 3 unpaid days because of personal illness, emergency, or injury. Employers, once again, collective or covered by a collective agreement, will likely have greater benefits than these 3 unpaid days. So the collective agreement should be consulted in the event an employee seeks to exercise any sort of sick leave. If an employee is self-isolating but is not sick, the employee may be able to work remotely, in which case there's no need for the employee to actually take a leave of absence. If, however, the employee is healthy, self-isolates, and is unable to work, the new COVID-19 related leaves of absence should be reviewed to see if the employee is eligible. There are also a number of leaves available to employees in the event a member of their family member is ill. Given the number of cases in Ontario continues to rise, even if we haven't seen many employees exercise these rights to date, there remains a good chance that they may do so in the weeks and months to come. Without getting into too much detail on these leaves, employees may be entitled to 3 unpaid days for personal illness, injury, or an urgent matter relating to a family member, 8 weeks to care for a family member with a serious medical condition, 28 weeks to provide care to a family member where there is a significant risk of death within the next 6 months, and 17 weeks to provide care for a critically ill adult, and 37 weeks to care for a critically ill child. Again, those employees subject to collective agreement may have greater rights than those set out under the Employment Standards Act, so those collective agreements should be consulted. Notwithstanding that these leaves are available to employees, hospitals and long-term care homes under the new powers granted to them by the government's order do have the ability to defer leaves of absence even when established by statute. That said, just because they have this ability doesn't necessarily mean that it needs to be exercised if the employee's looking to exercise their right related to sickness or to family care. As mentioned, no medical notes required for COVID-19 related leave. Medical notes may typically be requested for sick leave and some of these other leaves, but practically speaking, in the circumstances, healthcare providers are swamped, and you likely don't necessarily want your employee physically visiting a healthcare facility unless they are required to do so. One circumstance where I would recommend requiring a medical note is if the employee had COVID-19 and is looking to return to work, just to make sure that they are able to return to the workplace safely. Next, I want to briefly touch on some health and safety concerns. As Kathryn mentioned, under Ontario's Occupational Health and Safety Act, all employers and supervisors have an obligation to take every precaution reasonable in the circumstances for the protection of workers. Now, in practical terms, this means personal protective equipment should be provided to workers wherever there are health or safety risks that can't be adequately controlled in other ways. This personal protective equipment can reduce or prevent a worker's exposure to a health hazard in the workplace and can include things like respirators, masks, gloves, protective clothing, face and eye shields, etc. Now, employees also have an obligation to report any health and safety hazards that they're aware of. Needless to say, and as Kathryn mentioned, employees and unions have been very vocal about the level of personal protective equipment that's been provided to them thus far. And just yesterday, a law firm sent a letter to all SEIU, home care and community care facilities outlining their concerns about alleged failures to provide appropriate equipment to frontline workers, essentially threatening to take any legal action available to them if the employers fail to do so. The important question, and in terms of determining what may be considered reasonable precautions in the circumstances, employers should be looking to public health authorities for guidance. The Ministry of Health, for example, is regularly providing updated guidance documents for a number of healthcare sectors related to COVID-19. Following this guidance, along with any other prudent measures in the circumstances, will help minimize any risk of a finding that reasonable precautions weren't taken to protect employees. Kathryn also mentioned a number of other measures that can be taken, including documenting all attempts at procuring appropriate equipment for staff. At a minimum, if employees do run the risk of becoming infected at work because of the work they perform, they should be provided with appropriate equipment based on public health guidelines to the extent possible. Also keep in mind that if you have an employee who's vulnerable, such as if they're over 65, they have a compromised immune system, or any sort of underlying medical condition, then the obligations towards this specific employee could be different from other employees and should be assessed on a case-by-case basis. In terms of work refusals, employees do generally have the right to refuse work that they believe is unsafe to themselves or others. Healthcare workers, however, in certain workplaces do not enjoy this right. The workplaces where healthcare workers' rights may be limited include hospitals, long-term care homes, psychiatric institutions, mental health centers or rehab facilities, residential group homes or other facilities with behavioral or emotional problems or physical, mental, or developmental disability, ambulance services or first aid clinics or stations, or laundry, food services, power plant, or technical services used in conjunction with any of the above. So in these workplaces, healthcare workers generally they generally retain the right to refuse unsafe work, except when the potentially unsafe circumstance is inherent in their work or is a normal condition of employment, or where the refusal to work would directly endanger the life, health, or safety of another person. Given many of your employees are working on the front lines with individuals with suspected or confirmed cases of COVID-19 as part of their regular duties, it's unlikely that these employees would have the right to refuse work on this basis, assuming, of course, that appropriate precautions have been taken and that the work is otherwise safe to perform. For those workplaces that fall outside of these exceptions, the Occupational Health and Safety Act does set out a two-stage process for a work refusal. Workers generally required to immediately tell their supervisor that the work is unsafe and explain the circumstances for the refusal. The supervisor or employer generally must investigate immediately in the presence of the worker and attempt to resolve the situation. If it's resolved at that point, if appropriate precautions are sort of put in place, then the worker is generally expected to return to work. However, if the worker continues to refuse because he or she has reasonable grounds for believing that the reason for the work refusal continues, it sort of goes on to the second stage of the work refusal process. And in that stage, it essentially involves calling in an inspector from the Ministry of Labor to perform their own investigation. The inspector is required to give a decision in writing to both the employer and to the employee. And the inspector generally has the power to order that the employer make any necessary changes to make sure that the work is safe to perform. Just to provide a quick example, during the SARS outbreak, many employees exercised, or at least attempted to exercise, their right to refuse allegedly unsafe work. There's one case, 2 airline ticket agents engaged in a work refusal out of fear of contracting SARS while interacting with passengers. Those employees insisted on wearing gloves and face masks in order to continue in their roles. When the employer investigated and the subsequent health and safety investigation found that no danger existed to justify the work refusal. And importantly, that conclusion was based on guidance by public health authorities at the time, including the World Health Organization and Health Canada. And that decision was ultimately upheld by the Labor Relations Board. And obviously that decision is based on its particular facts, but it does offer some guidance for employers in terms of their obligations relating to work refusals in the context of a pandemic. Though, of course, a work refusal should be assessed and determined if it's reasonable based on the specific circumstances. Now, conscious of the time, just want to briefly touch on employment insurance benefits. It's been a fairly hot topic given the number of layoffs that have occurred and given the government's recent announcements about further supports. So first we have EI sickness benefits. These are meant to provide a measure of financial support to workers who are unable to work due to illness, injury, or quarantine. These people have usually, or sort of one of the requirements is that they experience a decrease of more than 40% in their earnings for at least 1 week due to their inability to attend work. Normally, in order to qualify for these benefits, employees must get a doctor's note showing that they are unable to work for medical reasons, but the federal government has waived that requirement. There's also usually a 1 week waiting period for receiving these benefits, similar to a deductible that you'd pay for other types of insurance, during which you typically would not receive EI sickness benefits. But the federal government's waived that period as well, meaning that employees who are sick or who are subject to quarantine or self-isolation due to COVID-19 will be eligible to receive EI sickness benefits for the entire period that they're off work. Second type of EI benefits are regular benefits. These provide up to 45 weeks of income replacement for employees who lose their job through no fault of their own. So that's through, what we've been seeing in terms of temporary layoffs or, even permanent shutdowns. To be eligible for regular benefits, employees must have been without pay for at least 7 days and must be actively looking for work. And then just want to touch on the new Canada Emergency Response Benefit. The federal government had previously proposed 2 new separate emergency benefits, one for unemployed Canadians who are not eligible for EI, and one for workers who are off the job due to illness or caring for someone who's sick. Just yesterday, the government announced a change to this approach, combining the 2 benefits into a single benefit called the Canada Emergency Response Benefit. And that new legislation received royal assent yesterday afternoon. In terms of eligibility for that benefit, the wording's quite broad in the legislation itself, and it basically applies to both employees and self-employed individuals who stop working due to reasons related to COVID-19 for at least 2 weeks. In the government's announcement yesterday, it provided a bit more clarity, stating that individuals would receive up to $2,000 a month for up to 4 months. Now, in terms of who qualifies for that benefit, the government also announced that it would cover Canadians who had lost their job, whether temporarily or permanently, who are sick, quarantined, or taking care of somebody who is sick with COVID-19, as well as working parents who have to stay home without pay to care for children who are sick, or who are at home because of school and daycare closures. The benefit would apply to wage earners as well as contract workers and self-employed individuals who would not otherwise be eligible for EI. And for anyone wondering if they can simply quit and get a free ride, the legislation specifically exempts workers who quit their employment. Applications for these benefits are expected to open in April, though an exact date has not yet been set. Ideally, for many of you, there won't be the need to lay off any employees, just given the nature of the work, whether permanently or temporarily. So this new benefit may not be overly relevant to your employees. But for those of you that either have laid off employees or are considering doing so, this should come as welcome news to them, especially to those who might not otherwise have qualified for EI benefits. I see we're a couple minutes over time, but that does conclude this morning's coffee talk. If you have any further questions relating to anything discussed today or otherwise, please feel free to reach out to Kathryn and myself or your regular Miller Thompson lawyer, and we can help you out as best we can. Thank you for your time this morning, and stay safe.